Hello everyone, myself Veren Sharma, your faculty for Polity, Constitution and Governance. Today we are here to discuss a topic regarding judiciary, and we will be discussing a current topic regarding Presidential Reference 2025. Let's begin with the question and overall concept. Presidential Reference 2025. What is the constitutional provision for this and why in 2025 it has been used by the Government of India? From constitutional perspective, Article number 143 of the Constitution provides for advisory jurisdiction of Supreme Court. So, according to this, the Supreme Court may refuse to give advice, or Supreme Court is under obligation to give advice to the President on the questions asked in the reference. If it is post-constitutional matter, court is not under obligation to give advice. But if it is a pre-constitutional matter, then it is obligation upon the court to give advice. So the point to remember, pre-constitutional and post-constitutional matter, anything which came before the commencement of Constitution, 26th January 1950, will be considered as pre-constitutional, and courts are under obligation to give advice to the President. However, a matter which is arising after 26 January 1950 are considered as post-constitutional, and court is not under obligation to give the advice. Further, why this presidential reference have been used in 2025? So the overall background of this is Government of Tamil Nadu versus Office of Governor of Tamil Nadu 2025. This judgment came from the court, and in this judgment, court has exercised Article 142 of the Constitution, which is there for the complete justice. And by using this article, court gave deemed assent to 10 bills passed by state legislature of the Tamil Nadu. And court has also used this article to give time limit for President and Governor under Article 201 and Article 200. And maximum 3 months was prescribed for the President and Governor of a state to exercise these powers under Article 200 and 201. Now, this is something which is creating a new challenge, that court has used its power and prescribed the time limit for a constitutional body. Because here, the Governor of Tamil Nadu, that office was keeping the bills pending for 2 to 3 years and not responding on those bills. When Tamil Nadu government has challenged it in the Supreme Court, court gave the judgment in favor of the state, and instead of governor, it is court who gave the deemed assent to this bill. And this has raised the questions. Can the Supreme Court prescribe time limit for constitutional authority by the Supreme Court order? And second, can you replace the role of governor or president by any another constitutional body? We can challenge this decision of the court to a higher bench because this decision was given by a two judges division bench. It can be raised before a higher bench or by the constitutional bench. Government took the initiative to approach and challenge or seek clarity from the court by filing the presidential reference under Article 143. So in this presidential reference, the government has asked some broad questions like what are the powers or options available to a governor? Under Article 200, this is one question asked by the government. Another question which is asked by the government is, can governor exercise his discretion or the governor is bound to act on the advice of the Council of Ministers? Means, can governor exercise discretion or bound to act as per Council of Ministers headed by Chief Minister? That kind of question. Plus, under Article 361, governor and president are exempted from judicial review. So if they are exempted under judicial review, so can you file a case against the governor for discharging their constitutional obligation or for not discharging their constitutional obligation? These kind of technical questions have been raised in the presidential reference. Plus, can the court prescribe timeline for president and governor under Article 201 and 200 respectively? 201 for president and 200 for governor. It is not regarding Article 111 of the Constitution, where President deals with the Union Government Bill. This is all regarding Article 200 and 201, where President is going to discuss a bill reserved by Governor of a state. These are the broad major questions raised by the Government of India to the President, and let us see what are the major answers given by the Supreme Court in this regard. Regarding Article 200, Court clarified the governor of a state has three options. One, he may, that language should be like governor shall declare. Now imagine this is a language. Governor shall declare either of the following option, and that is assent to a bill or withhold, or the third option is reserve for president. These are the three options under Article 200. And as per court, this is substantive part of Article 200. That means the main part of Article 200 is these three options. If the governor has given assent, the bill will become an act. If the governor has withhold the assent, so in that circumstances, the bill will not become an act, but the bill will also not lapse. Reason, we are a parliamentary form of democracy. Our governor is just a nominal head of the state. So without advice of the Council of Ministers, the bill will not come to an end. And therefore, the option which we read in the books is governor may return. Ab this may, earlier languages shall. So wherever it is shall, it is like binding upon you, and where the language is used as may, that gives you a discretion. So here, if the governor is declaring withhold, after that he is expected to exercise this option, return the bill for reconsideration of the assembly. And when this is done, so after this, assembly will repass the bill. And when the assembly has repassed the bill, the governor of the state shall not withhold the bill therefrom. So he is expected now that once a bill is repassed, you are supposed to give your assent. But the governor of Tamil Nadu, instead of giving assent, he kept the bill pending for reserving. Means first he applied withhold. After that, he has not returned the bill. State Assembly has repassed the bill. And thereafter, when the bill was repassed, he is expected to give assent, but he reserved that bill for the consideration of President. Total 10 bills. And that action have been declared invalid by the Supreme Court. And that is why this entire chain of event initiated. And here the court is clarifying you have just three options. The fourth option is a proviso. It is first proviso to article number 200. And also it is made very clear, if the bill is a money bill, then you cannot return that bill for the reconsideration of the assembly. So this is generally called suspensive veto. You can apply suspensive veto in case of ordinary bill and in case of financial bill, but not in case of money bill as a governor of a state is concerned. And regarding constitutional amendment bill, governor is having no role because that assent will be given by the President of India only. So these are the options available to the governor. So court has clarified what are the options available for governor under Article 200. Only three options. Then related to this was a question that whenever a bill is passed by the assembly, it is presented to the governor, and as per the logic, Council of Ministers headed by CM, they advise the governor to discharge his function. So imagine the governor has been given advice by the council, you give assent. But as a governor, I want to reserve this bill for the consideration of President. And that is this question. Can governor exercise discretion or bound to act as per advice of the Council of Ministers? This answer is clarified by the court that governor may use his discretion. And the reply for this discretion also comes from Article 163. 163 is relevant to remember because here Council of Minister headed by CM to aid and advise the governor in exercise of his function, except the governor is required to act in his discretion. So if the bill passed by the state is affecting the central interest, the bill is related to reasonable restriction on center-state relation, in such circumstances, as a governor, I am under constitutional obligation to reserve the bill for consideration of the president. State government imposing tax upon a union agency, let's say NHPC, which is producing water or which is producing hydroelectricity by using the dam and then generating the resources. If state want to impose tax, such bill can be reserved for the consideration of the president. These are constitutional provision mentioned under article number 288 in this regard. That's why clarified by the court, the governor can exercise discretion while exercising article 200 regarding the state bill. This takes us to the another set of question, that suppose a bill is passed by the state assembly and goes to governor for his assent, and governor is keeping the bill pending for indefinite period. So technically whatever he is doing is a part of his constitutional position. And in such cases, can you go to court and court can exercise the power of judicial review regarding the governor? Because as per Article 361, the governor and president are exempted from judicial review. Court has clarified on this issue that the governor and president are exempted. That means the answer is yes. The court has clarified the governor and president are exempted from the judicial review with respect to their official duties. However, if the bill is passed by state assembly pending with governor and the governor is keeping the bill pending for indefinite period, which is called prolonged delay, indefinite explanation, delay tactics, then in such circumstances, state government may approach to Supreme Court and Supreme Court will exercise here limited mandamus. And court has clarified here that office of governor and governor is exempted under Article 361, but office of governor is a public office and public office is subject to judicial review, and that's why the term is used as limited mandamus, and limited judicial review can be applicable in such a case. So governor is exempted, but his office is subject to limited judicial review by the Supreme Court with the help of limited mandamus. Mandamus is like a direction, but the point here, as a court, we cannot tell to the governor what to do with the bill. But we can ask the governor, what are you doing with the bill? Whatever is your opinion, you please take this opinion in a limited span of time, or by the next hearing you may clarify. These kind of situations can be possible under application of limited mandamus, because mandamus is more like a directive issued to a public office, and that's why the logic is used here. Governor office is a public office, limited mandamus is applicable to him, and that is judicial review. So governor is exempted under Article 361. Office of governor is subject to limited mandamus and judicial review. Plus, government have also asked to the court, and question is, can Supreme Court prescribe time limit for the president and the governor? So answer given by the court in this regard was, it would not be appropriate to prescribe and bound governor and president by the time limits which are prescribed by the judicial order. This is a very unique point to remember, because in the 2025 judgment of Tamil Nadu versus Office of Governor, court prescribed 3 months time limit, which actually became a matter of concern regarding the powers of president and governor in this regard. And here the court is giving completely a different clarity about this article, and court is saying we cannot bound the governor and president by court prescribed time limit. That means that 3 months time limit given in the previous case will stand technically nullified or non-applicable for the future, because this is a judgment coming from 5 judges constitutional bench. So 5 judges constitutional bench is removing these doubts and giving more clarity about the powers of governor. Then one more question was raised in this presidential reference. Can we use Article 142 and replace role of governor and president by any other constitutional authority? This question is more about the idea of deemed assent. This is more about the question of deemed assent, because the court gave deemed assent to 10 bills. And this also have been clarified by the Supreme Court that under Article 142, there is no power of deemed assent. It does not exist at all. Plus, the role of governor and president cannot be supplanted by any other authority. That means no one can take the role of governor or president in the procedure of lawmaking. So there is nothing called deemed assent to be given regarding the Article 200 or 201. So governor will be giving the assent, and if governor has reserved the bill for the president, then president will decide on the aid and advice of the Union Council of Minister. That is a clarity provided by this particular judgment. So these are all the different major important points we can remember regarding presidential reference of 2025. In a easy summarized manner to remember, first thing, Article 142 does not consist anything like deemed assent. Plus, the timeline prescribed for the president and governor will remain non-applicable. If the governor is doing prolonged delay or indefinite delay, then a limited mandamus can be applied. And this limited mandamus is applicable only because governor and governor's office are two separate identities. Governor is exempted, office of governor is subject to limited mandamus or judicial review. These are the major takeaways for this topic. It can be useful for general studies, current affair application in the polity and governance, so as it is also applicable for the optional subject like public administration, paper 2, Indian administration. I hope this will help you to clarify all your doubts regarding the Presidential Reference 2025. See you in the next discussion. Till then, bye-bye.